from 1994 to 97 and threw for 11,201 yards and 89 touchdowns, also completing 62.5% of his passes. Arkansas hired Chad Morris as its next head coach. Morris succeeds Brett Bielema, who was fired November 24th. Morris was the former head coach at SMU in Dallas. Morris became the top candidate after Mike Norvell signed a contract extension to stay at Memphis. The hiring comes late Tuesday afternoon from new athletic director Hunter Urachek. The Tennessee Vols lost a crucial commitment for the class of 2019. Wide receiver Cameron Wynn from Chattanooga's Notre Dame High School, considered a four-star prospect, also ranks as the number 18 prospect in all of Tennessee. Wynn has prospective offers from Ole Miss and Vanderbilt. Sam Jordan, News Talk 92.7 Sports Now.
Expect mostly cloudy and chilly weather out there through your afternoon. Highs only into the upper 40s to near 50. Tonight, lows into the lower to middle 30s with some leftover clouds. For Thursday, partly sunny, highs into the upper 40s with colder weather returning for Friday and the weekend. Experience the magic of the holidays with Rock City's Enchanted Garden of Lights. Create your one-of-a-kind adventure with dazzling views and almost a million colorful lights. Visit CRockCity.com for all of the magical details. And I'm Storm Team 12 Chief Meteorologist Patrick Hoare.
Broadcasting live to over 1 million souls in Chattanooga, the Tennessee Valley, and beyond on frequency modulation 92.7. Sean Hannity, 25,000 watts on digital FM 95.3 HD4. CBS Radio News, NASCAR, Bloomberg Markets, David Tulis, streaming strong at Noogaradio.com. Live on YouTube and Facebook. Nooga Radio, News Talk 92.7. Chattanooga Radio.
Good morning, Chattanooga. Welcome to Legal Bites. This is Jim McCoon and Clay Whitaker. Good morning, Clay.
Good morning, Jim.
And welcome to this week's edition of our show. And Clay, this is an anniversary show. I don't know if you realize or not, but 1 year ago, it wasn't to the date, but to the week. 1 year ago, we started this venture in trying to produce and communicate legal issues for the public and to discuss what's happening, not only maybe contemporaneously in the news and discuss those issues, but also discuss issues that the public can consider and use in their businesses or in their lives. And basically our whole intent here has been to be a public service. And to broaden that, you and I agreed that, I guess for the past 3 months, despite the fact that we may have a topic that we're discussing that day, we have opened up the phone line so that if there are any issues you out there in radio land or dealing with that you just want to talk to an attorney and just maybe bounce it off as what's happening or get a better handle on what your rights are, you call us. Our number here at the station is 423-800-8949. That's 423-800-8949. And call us with your topic, whatever it is, regardless of what we're talking about here on the show today. And Clay and I, if we know the answer, we'll let you know as we're talking. And if we don't know the answer, we'll be happy to talk to you from the office, and we'll look at it for you and try to give you a response as to what's going on and try to help you out, because that's what we're about here today.
That's right, Jim. It's a great day for our anniversary. Wouldn't have known that if you hadn't pointed it out. And I know all of our listeners, our many listeners, would certainly appreciate the public services that we've given in regards to these legal things we've talked about. We look forward to some more calls. So give us some calls today. We'd be pleased to talk with you about any topic. But today's topic, we're going to talk a little bit about the general considerations every person who has the dream of owning their own business should think about. And don't wait until after problems begin. Talk to your lawyer first.
Right. And what really brought this topic about is not only we're year in, and year in our profession means not only cases that are in litigation, the clients want to try to get them resolved. People want to get things closed out and light, but from a business standpoint, there's a lot of work to be done to close out year end on people that are on a calendar fiscal year end with respect to various compliance issues they may have and trying to close out their work. And so we're advising and helping in a lot of that area. But it's also the start of a new year. And so many people have contacted us, and this has been my experience for, I guess, 35, 36 years of practicing, or have been looking at thinking, wanting to make changes in their business or their business structure, maybe even starting a brand new venture in business. And they're looking at, if I get to a new tax year, that's the perfect time to do it, because then I don't have carryover issues. I can just start clean on January 1. And so we get the calls about what should we do and how should we do it. And we start going about trying to assist them.
Well, Jim, is that a real legal consideration? The idea that you need to start at the beginning of a year, or can you start anytime with a new business?
Oh, you can start anytime. It's just easier on the books if you're going from, maybe you were a sole proprietorship and, you've been out there doing what you're doing, but you're growing, you're concerned about potential exposure for you and your family and the things that you're building because of the business and the like. And so you decide that you want to set up a structure just to give you some protections, or you may be looking at trying to bring in an investor or a partner, or maybe take a key employee and give him equity and give him ownership. And because of that, you need suddenly a structure, because once you give him ownership rights or interests, it's no longer a sole proprietorship. The word sole is gone. And suddenly, like it or not, you are a general partnership or a joint venture if it's a limited time frame, but it's basically a general partnership from there on once you've taken that employee up and given that employee some ownership interest in the firm.
Well, Jim, maybe it's a good time for us to give a shout out to a little caveat here in regards to these issues. But, we do have some taxability in terms of advising people, but certainly with the uncertainties surrounding our current, I guess what would be our future tax code, our talk today is going to be generally and in general terms about what things people should think about or talk about.
Absolutely. Absolutely. Life's changing in the world, and it's changing based upon things that are happening right now in Washington, D.C.
I put my call out to those guys, but I'm still waiting on it. They hadn't returned my call yet. Tell me what's really going on with the tax code.
Yeah, well, all you got to do is watch the news or the fake news, and they'll tell you exactly what's happening.
Well, I'll keep doing that, Jim. I'll keep waiting for the truth to come out. So.
Well, let's talk about the various types of entities that you can have or formations you can have for a business that you might be considering. Of course, as I said, we've got the sole proprietorship.
Well, what's that? When we say sole proprietorship, that's a nice word, but what does it really mean for the folks out there who are trying to start up a new business?
That's the average Joe that says, "Hey, I've got an ability to do something, and the public is willing to pay me to do it, and therefore I'm just going to start doing it. I don't have any type of a structure or a business entity set up. It's just me doing it. You write your check to Jim McCoon, and Jim McCoon come and rake your leaves off your yard."
So does anybody have to ask for permission to begin a business as a sole proprietorship? You got to talk to the government and let them know what you're thinking about doing?
Nope. You just go do it. And once you do it, you're going to have your tax liability is going to be on your personal tax return. And your social security number will be your reporting number for your earnings and losses, and you're going to do everything just the way you are. Now that changes once you make a decision that either you want to set up some type of a structure or entity to protect you and your assets, and maybe be different from you, so that the public doesn't look to you for everything, but you've got a business they're looking to. Or it changes if you bring in another owner, as we just discussed, whether it's a key employee or an investor or someone else who comes in to take some equity position or ownership position in this business that you're thinking
about. You were talking about that a minute ago. You mentioned partnership as one thing that might surprise someone. They might ultimately end up being a partner with someone and unwittingly have done so.
Right. I mean, once you have brought that person in and given them an ownership interest in whatever business activities you're taking, then you and that person are suddenly partners in the eyes of the law. And there are good things and bad things about it. Certainly it's good things is having someone that's working with you, pulling the yoke. I mean, that's what makes a marriage so beneficial, is that there's two of you trying to move your family together.
You're thinking about a modern day marriage though, Jim, right? That's not the way things used to be. It used to be one person pulling the yoke, and then someone.
I'm not even going there, Clay.
Okay.
I'm not even going there.
All right. Well, we don't want to stumble around in marriage or in business. We want to make a plan. So,
right. And that's where I think things needs to happen is, well, let's sit down and talk, and really it depends upon, what your plans are, what you want to accomplish, how many people are going to be involved, how do you expect to obtain the funding for what you're doing, whether it's by bank loan or whether it's by investors, and what are you going to give in return for, say, an investor? Are they going to take back equity, or are they going to take back debt? And then I guess the final issue is are the registrations and licensure issues you got to consider in going about this. For example, does the license has to be held by the individuals, and registration of the professional or business activities, or does it need to be held by a business? So as to broaden the scope of who can do it, and is that allowed by the state that's the licensing entity? For example, in the law firm, we each have our individual license. The firm isn't licensed, but our firm is a PLLC, which is a professional limited liability company. And only a professional entity that is that's made up of licensed equity holders can be a PLLC.
Well, and so, Jim, when you start this planning part of this, you're going to get into selecting types of businesses. You mentioned partnership. We also have limited liability companies or limited liability partnerships. I think those are available in all the 3 states that I practice in, Georgia, Tennessee, and Alabama. You also have what we would call S corporations, which is a designation that's strictly related to the tax code, but it's a corporation, a domestic corporation. It can be formed in these 3 states that we're in. And we also have the partnership you previously mentioned. Is there any other?
Oh, you got a C Corp.
C Corp that we could.
Standard corporation.
Yeah. And so we got C Corp, S Corp. And those are all that can all be formed under Tennessee, Alabama, or Georgia laws. Is that right?
Yes. Absolutely.
And so is there any other form of business that if you go see the lawyer, you need to consider?
Well, I mean, there's probably not for today's discussion, but you've got charitable entities that are set up, 501c3s and like, that are really out there, and they're either a 501c3, 501c4, they're service organizations and the like.
For not for profits.
Yeah, not for profits effectively. And so I think from that standpoint, there is a different type of entity, but I don't think that's what we're really trying to focus on today. We're talking about today is the person who's got a for-profit business idea, and what should they do? What should they consider? And then, what all will that mean? And one of the things I touched on a minute ago was, as a sole proprietor, you're talking about using your social, and everything's reported on your personal return. If you go to a separate entity, whether it be a partnership, or whether it be a LLC, or whether it be a corporation, either an S or C, then you're going to have a different tax reporting entity at that point in time. And you'll end up getting an employee ID number for that entity, and that employee ID number will be attached to the checking accounts and bank accounts of that entity, and that will either have a tax liability if it's a corporation, like where it could actually have to pay taxes for the profits earned by that entity, or it could simply be a pass-through, where, for example, with an LLC, where even though there's a reporting of all the revenues and losses, that's the actual tax effects are actually just passed through to the members who are the equity owners of the LLC.
Well, one of the things that always happens in our practice when people come and want to form businesses is their concern is that they have a desire, at least, to protect their assets, so their personal assets. And one of the ways that they think that can be done is by under one of the previously mentioned forms we talked about, whether that's a partnership, limited liability company, or partnership, or some form of a corporation. That's one of the things we always advise people about when they're looking to form a corporation, is that is possible to do it, but there are some limitations to it.
Well, there is. It is certainly, that's one of the reasons why corporations and limited liability companies, which are effectively a partnership with corporate liability protections attached and surrounding it, that's one of the main reasons why you want to set up those structures. But in reality, a new business, a startup business, a closely held business, when it goes out to get a loan in its name as an LLC or as a C Corp or as an S Corp, they're going to expect personal guarantees from the majority shareholders. So to the extent you were hoping to be able to avoid bank debt or indebtedness incurred, that's going to happen. A lot of your vendors, especially if you're in a startup mode, are going to want personal guarantees from at least the principal officers or operators in extending credit to this new entity and the like. And then from a tort standpoint, say there's a violation, or from a contract breach standpoint, you technically have protections, but those protections only adhere as long as you comply with what's required by the law in maintaining that entity and maintaining its separateness from the shareholders and owners themselves.
So we find that quite a bit, that folks get involved in business formation but don't take care of the day-to-day requirements of compliance that are set forth in our statute, at least Tennessee statute. And because they don't do so, they put themselves at great risk for their personal financial indebtedness as a result of things that may occur in their business.
Right. What you'll see is say company XYZ has breached on a major contract, and the creditor will go after company XYZ and realize the company XYZ doesn't have anything. And one of the reasons it doesn't have anything based upon their investigation is because it was used basically as an alter ego for Joe, the principal or maybe sole shareholder, and that he used the corporate accounts as his personal wallet and was buying whatever he needed personally through the corporate account, wasting corporate funds and the like. And so what you end up with is an alter ego claim and a theory to pierce the corporate liability veil and go through and go against the individuals behind it.
Well, we're here on Legal Bites. This is Clay Whitaker and Jim McCoon. Our number is 800-8949. We're talking about issues that people want to consider when they're forming a business. But that's not the only topic. This is our anniversary show. We'd love to hear from you on any topic. So all of our callers and listeners who have previously called in, please consider giving us a call. And if there's another topic you want to discuss, we'll be pleased to discuss it with you.
Yep, exactly. And, and in going about starting your business, I strongly urge people to put together a team. I think there are three people that are absolutely necessary when you're starting a venture. I think you need an attorney to advise you. And there are a number of wonderful business attorneys in the Chattanooga area that are available and be very helpful to you, very capable. And then two, I think you need to have an accountant, a CPA, to advise you on setting up your books and your compliance issues with both the IRS and with the Tennessee Department of Revenue, and help you with trying to set up your payroll reporting and all of that. And then I think you need a relationship with a banker, because at some point in time, that company is going to want financing, is going to need some accommodations. And so you need to build a relationship with a banker. And I think that those three people are the critical team for any new venture.
And Jim, I was advising someone the other day about this topic, and I said the other person that you absolutely need today is someone that is a technology specialist. You've got to have someone that can deal with your computers, that can deal with software, and that can deal with a relationship with the public and how that public can transact business with you using technology.
That's a fair statement. I mean, today with so much internet marketing occurring, with so much with respect to a lot of smaller businesses instead of having a showroom or setting up merely an internet means of shopping with them. And they're merely shipping or drop shipping goods that they're providing to the public from their source, or maybe even what they're manufacturing, then, I agree. I think, the aspects of having someone that can do the technology and set up a means where you've got a user-friendly website, you've got a local area network where you can deal with your other employees as well, so that you need to have something that not only allows you to deal with the public, but also deal internally. I think those are important issues.
Well, and so besides the general considerations we've talked about, those being how to divide up ownership, how to apportion the way in which your business might consider equity owners, and then the issues related to liability and the protection of personal assets and distinguishing between business assets and personal assets. There are other issues that people look at in the form of how they handle their business. One of them might be addressed by the way that we would use operating agreements or bylaws for corporations.
Oh, absolutely. I mean, when you look at a limited liability company, one of the really nice features of an LLC that you don't have available in a corporate situation is the flexibility in how you can structure your membership. You can have members that are financial members only. That is, they participate only in the profits or losses of the business, but they have no governance rights. They have no ability to control the business. They just have a right to a return on their investment based upon how the business goes. So you can have basically tiers of equity owners inside the LLC that may or may not be equal in governance rights and in financial interest rights. And, the amount of their investment doesn't necessarily have to align with what they're receiving back as a member. So I think that's got to be decided and considered. Also, when you're dealing with an LLC, you've got to decide whether you're going to be member managed or director managed. And I will tell you that unless you're really a sole member or single member LLC, I strongly urge my clients to go to the director managed. And one of the main reasons is why, if you're member managed, remember, an LLC is similar to a partnership. So that means that any member can bind the LLC and bind the other members' interest in the LLC. So, when you have a member managed, it's basically having a bunch of general partners. But if you've got a director managed, then those members have appointed a board of basically directors who are effectively the officers that are going to have the control with respect to being able to bind the entity. And I think that's an important consideration.
That's a great point, Jim. And, a lot of people don't understand when we say the word binding the corporation, what we're really talking about is that those people are allowed to speak on behalf of the corporation or partnership or limited liability company. And by doing so, they're able to announce to the public that they speak for that company, and the public is allowed to rely upon what they say,
right?
Which is when that's what you're talking about,
right? And in actuality, there's two types of authority. One is the actual authority that the other members or the other shareholders or the board of directors may have given to that individual, but you also have apparent authority, and that is the fact that you put that person in a position, even though you may not have given them that authority, you've put them in a position where the public can rely, or maybe believe that it can rely on them in binding the entity. And so you get into an argument basically of constructive agency as opposed to actual agency.
And so that's something we see in our practice is a lot of things that we address are things that are learned from experience or learned from the failure of decision-making when people get into trying to form their business. So we come in at the end after the problem arises and have to fix that problem. One of those areas where these things occur is just what you mentioned, the area of agency. Whether or not someone is authorized to bind the entity, or in this particular instance, it might be able to, for instance, you're talking about a partnership, it's smaller in terms of the number of people can be bound, potentially at least, and you might bind that group of people and be responsible for the entire debt or the entire obligation, whatever it might be.
That's what so many people don't understand. You're talking about a general partnership. Well, they say, well, Steve only has 10%. The the other two of us, we own 90% of the partnership, and Steve hasn't done anything. Well, Steve, if he's a general partner, can bind the partnership to the world. And the fact that he may only have a 10% interest means nothing.
And many times that's the way that people do dirty tricks on people or do things that aren't appropriate that cause the demise of the business, and maybe intentionally, maybe carelessly.
Absolutely. I agree. And it's something that hopefully through advice we can avoid. Well, we're to the half hour and again, our anniversary show. So we'll talk to you as we return after the news and look forward to you on the other side of the hour.